Mark, just another question from a student too. They've asked, can a journalism student walk into any courtroom at any time from that reporting?
All right, so the courts are meant to be open. There's a principle called open justice, and so the starting point is that all courts are open unless there is some other restriction. Now, and that's open to the public to be there to watch what happens in court. Now, some courts are closed. In some places, they're closed because they're a juvenile court or they're trying a sexual offence and a victim is giving evidence or something like that. So the court would be closed in those sorts of situations, depending on where you are. So in some states, you're allowed to report children's court, but not identify the people involved. In other places, you're just not allowed in the room. Now, journalists have a slightly different level of access than the rest of the public, including students. So because you're a journalism student does not give you any great rights over the rest of the community. Fully fledged journalists have special seating. They have the privilege of being allowed to take notes in court, for example. And in some places they have the privilege of being able to use recording devices for non-publication purposes and also to use their devices for tweeting or emailing their workplace and that sort of thing. So these are special privileges available to journalists. I have been asked when I've had students in court at some times, on some occasions, I've been asked by the magistrate, why are these people taking notes in my courtroom? And I've had to stand up and explain that they are journalism students checking, testing their court reporting skills, and the magistrate has accepted that. So it could be that a journalism student walking into a courtroom and starting to do all of these things would raise the ire of the judicial officer, and they would be best advised to check first with the court officials that this is okay that they do this. They wouldn't normally be allowed to use their phone or a recording device in court unless they were a journalist with that special permission. You've also got to remember... you've also got to remember that they are protected for a fair and accurate report of the case, and that would include coverage on ensuing days and on ensuing stages of the court process. So they couldn't just be there, for example, on the day that the prosecution's giving its evidence and publish a report on a student outlet about that, and then not follow that up with the defence's arguments in that case.
So, and another question that we had too, Mark, was what some of the biggest no-nos to avoid around social media? I imagine that can be pretty problematic with your court reporting as well.
Yes, so social media is a minefield as far as court and crime reporting goes. For a start, the courts don't interpret a tweet or a Facebook post as being associated with whatever it links to. So you'd have to be very careful if you were like summarising a court case in just a few words for, say, a tweet, and you weren't, it didn't have the context, because you would lose your defences to defamation and perhaps even publish prejudicial material. So there's that. You certainly can't use it in the courtroom without the permission of the judge or the magistrate, so that's a no-no. And you'd have to be very careful about engaging in social media commentary about the guilt or innocence of the accused, publishing material that might identify them in some way, for example, accessing the accused or a witness's social media feed and quoting from that. So there are a whole bunch of things that are danger zones with the use of social media in the courts.
So is there any final advice that you give for students who are delving into this wonderful world of court reporting?
Well, the only advice really is to really brush up on your media law and and take advice from somebody. You may not be able to talk to a lawyer or not be able to afford that, but you'd need to consult your tutor or someone senior in the area that knows about it before you embarked on a story that has these sorts of alarm bells ringing.
I think you spoke, Mark, about that intuition, that gut feeling that something's not quite right. You really need to trust that as a journalist.
You do, indeed.
And that's when you would refer upwards to someone else for advice.
Yes, and some organisations are larger and they do have lawyers available. Others have lawyers available, but they're charging you the $200 a question, and normally they then say, my fee is $200 a question, and what's your second question?
Best to know your media law first and avoid some of that. Thank you so much for joining us today, Professor Mark Pearson. That's fantastic.
No problem. Thank you.